Hello CA Foundation students, so this is our second revision video and we are going to cover another chapter which can give you 6 marks. It is chapter number 5, the LLP Act 2008. So as we have seen our first video, it is going to be a quick revision focusing on the keywords, very exam oriented, just for you to watch before the exam, not a detailed explanation video, but it will definitely be able to give you confidence for scoring well in the chapter of LLP Act 2008. So coming to the chapter, this part, what about when was the act passed, when was the president, when has the president given the assent, those things we are not going to look into it because I don't think that is much relevant for your exam. But what is relevant is, yes, the few points like LLP Act is applicable to whole of India. Anyways, all the acts which are there in your syllabus, they are going to be applicable whole of India. Structure of the act, के act में structure कैसा है, कितने sections, कितने schedules है, right? Contents, it has 81 sections and 4 schedules. First schedule talks about mutual rights and duties of partners. So if the mutual rights and duties anywhere, if you want to look into the act, they are given under first schedule. But for any other thing, like any other rights and duties which are fixed by the partners, you can look into the LLP agreement. But if it is not fixed, then you can look into the first schedule. Then the second schedule is about conversion of firm into a LLP. So partnership firm, can it be converted into LLP? Yes, follow schedule second. If you want to convert a private company into LLP, you will follow third schedule, and if you want to convert unlisted public company into LLP, you will follow fourth schedule. So note that listed public company cannot be directly converted into LLP. Another thing which is given in section 4, that Indian Partnership Act 1932 does not apply to the LLPs, right? What applies to the LLPs is only the LLP Act 2008. Now we know this basic thing, right? If we have studied in detail that LLP is a form of organization which combines the benefits of company and the benefits of a partnership form of organization, and we have a new form of organization, this LLP. Coming to the meaning and concept of LLP, an important word which you will definitely remember is LLP is a alternative corporate business vehicle. It is alternative corporate business vehicle which has the feature of limited liability, liability of partners. Limited liability मतलब किसका limited liability? Liability of partners will be limited, and it will be limited to the extent of their capital contribution. तो LLP का खुद का liability, LLP itself, it will be liable for the full extent of its assets, right? This form of organization allows the partners flexibility of organizing their internal structure. So whatever is the internal structure, that can be decided by the partners. So 4 to 5 points which you can remember for LLP, the meaning and concept of LLP. Coming to important definitions. पहला definition दिया है body corporate का. Why do we need to study this? Because section 5 says who can be a partner, and it says that a body corporate also can be a partner, right? We will look at section 5 differently, but I am giving you the reference. So that is why we need to study who is a body corporate. 4 things, 4 people are included in the definition of body corporate and 3 are excluded, that they are not to be termed as body corporate. कौन से 4? A company incorporated in India as per section 2 clause 20 of the Companies Act 2013, a company incorporated outside India, a LLP incorporated in India and LLP incorporated outside India. These are coming under the definition of body corporate. Then what is excluded? A corporation's sole is not regarded as body corporate. Cooperative society is not regarded as body corporate, and any other body corporate which the government may notify in this behalf, that will not be regarded as a body corporate. कौन 2-3 लोग नहीं है बॉडी कॉर्पोरेट की डेफिनेशन में? कॉर्पोरेशन सोल, कोऑपरेटिव सोसाइटी, एनी अदर बॉडी विच द सेंट्रल गवर्नमेंट में नोटिफाई. कौन कौन है वो हमने देख लिया. कमिंग टू द डेफिनेशन ऑफ बिजनेस. बिजनेस का डेफिनेशन क्यों इंपॉर्टेंट है? बिकॉज in another our topic they will say that LLP can be incorporated only for the purpose of business. Many a times this question is asked in exams, very easy question. Can a LLP be incorporated for the purpose of not for profit organization? In Companies Act, yes, you can incorporate for that purpose under section 8, but in LLP they have said that you can incorporate a LLP only for business or for profit motive. So business, it can be any trade, profession, service or occupation except any activity which CG may specify that this is to be excluded. Who is a designated partner? That is given under section 7. Important definition for an LLP. So which body can be regarded as a foreign LLP, there are 2-3 conditions. An LLP which is formed, incorporated or registered where? Outside India, but it has established a place of business within India. So incorporated registration उसका बाहर हुआ है, but it has a place of business in India. Both these conditions when fulfilled, you can regard it as a foreign LLP. So if a LLP is incorporated outside India and it does not have any place of business in India, can it be regarded as a foreign LLP? No, because the definition says it should have a place of business in India and it should be incorporated or registered outside India. Important definition, foreign LLP. Coming to another definition of limited liability partnership का मतलब and limited liability partnership agreement, very easy. LLP means a partnership formed and registered under the LLP Act 2008. Simple. And what is a LLP agreement? Any written agreement, not oral, written agreement between whom? Between the partners of LLP or between the LLP and its partners, जिसमें आपके mutual rights and duties दिए हुए होंगे. So an agreement, written agreement which specifies mutual rights and duties of the partners and their rights and duties in relation to the LLP. Rights and duties amongst partners themselves and rights and duties between the partners and the LLP, that is given under LLP agreement. Partner, who is a partner? So partner in relation to LLP means any partner, person who can become a partner in accordance with the LLP agreement. So quickly we will look at who can be a partner, that is given under section 5. Section 5 says any individual or a body corporate may be a partner in LLP. So individual or body corporate, and what does body corporate mean, that we have seen. But these 2-3 categories of people cannot be a partner in LLP. An individual shall not be capable of becoming a partner if he is found to be of unsound mind by the court of competent jurisdiction and the finding is in force. So if he is declared to be of unsound mind by court, if we say that some person is of unsound mind, that does not matter. It has to be a finding by a court and that finding is still in force. Unsound mind, undischarged insolvent. What does undischarged insolvent mean? It is different from a discharged insolvent. So if a court adjudicates a person as insolvent and that adjudication is still like in force, he is an undischarged insolvent. Or if someone has applied to be adjudicated as insolvent and his application is still pending. I have given that I might be declared insolvent and I have applied for my adjudication as insolvent. I also cannot be a partner in LLP. Though this is not a case, just an example. So these 3 people cannot be a partner in LLP: unsound mind, adjudicated as insolvent, or person who has applied to be adjudicated as insolvent and his application is pending, right? Minimum number of partners भी देख लेना है क्या तुरंत? Let's look at minimum number of partners. So they say every LLP shall have at least 2 partners if at any time, this is a very important provision, if at any time the number of partners of LLP is reduced below 2 and the LLP carries on business for more than 6 months. So they have given you the time of 6 months. If you carry your business with one partner not being there, like the number is reduced below 2. If it was 2, then if it is reduced below 2 and you are carrying the business 6 months while the number is so reduced, like you are carrying less than 2, matlab kya? Single partner. So if there is a single partner and if you are still carrying the business for more than 6 months, then what will happen? The person who is only partner of the LLP, the person who has been left as the only partner of LLP during the time that it so carries on business after those 6 months and has the knowledge of the fact that it is carrying on business with him alone. I am a partner in LLP. We were 2 partners. One of my partner died, and if I am carrying on the business for more than 6 months alone, I have not taken any other partner, and I know that I am carrying the business alone, then he shall be liable personally for the obligations of the LLP incurred during that period. So they will make your liability unlimited, in short. So this is an important provision. They are giving you 6 months time that you take another partner. If more than 6 months you are carrying on the business with knowing the fact that you are carrying on the business alone, then they will consider you like you are doing sole proprietorship and make your liability unlimited after the 6 months. Whatever is the liability of the LLP, that can be enforced against you. That are the provisions about number of partners. Coming to our definitions, one definition important which was remaining, small LLP. Now students get confused between the numbers of small LLP and small company. Do not do that. We will revise small company when we do Companies Act. The contribution of which does not exceed 25 lakh rupees or such higher amount. This is not relevant for us because what is applicable is 25 lakh rupees. So LLP whose contribution does not exceed 25 lakh rupees, that is, it is up to 25 lakh rupees, and it is not or, it is and the turnover does not exceed 40 lakh rupees. Where are we going to look at this turnover number? It is as per Statement of Account and Solvency, SAS, Statement of Account and Solvency for the immediately preceding financial year. So turnover is most probably, most of the times it is looked for preceding financial year, right? So turnover of as per the Statement of Account and Solvency as per the immediately preceding financial year does not exceed 40 lakh rupees, and the contribution, capital contribution, does not exceed 25 lakh rupees, and which meets such other conditions as may be prescribed. That is small LLP. Coming to section 4, we have already seen it, that Indian Partnership Act does not apply to LLP. Partners we have done, minimum number of partners we have done. Coming to section 7, designated partners, important. First we will look what is a designated partner, like who has to be a designated partner. They have given every LLP has to have at least 2 designated partners who are individuals. So what is important is he has to be a individual. Along with it, from the minimum 2, at least one of them shall be a resident in India. And what does resident in India mean? It means a person who has stayed in India for a period of not less than 120 days during the financial year. He is termed as resident in India. So if a person is a, say there are 2 partners, at least one of them has to be a resident, another person can be resident or a non-resident. Resident, what does resident mean? Because it is different as per Companies Act, different here, mentioned here differently, right? So you have to follow this for purpose of this act. One of them has to be a resident. Firstly, both of them have to be an individual. At least one of them have to be resident. In case of partner, there was no such condition that only individual can be there. It can be individual or a body corporate. There was no such condition of being a resident, but in designated partners case, 2 individuals at least, and at least one of them has to be a resident of India. Now, are designated partners different than their partners? No. If there are 2 partners, these 2 will become the designated partners also. But now what if all the partners are body corporate? Because a body corporate can be a partner, then how will the designated partners be appointed? So in that case, in case of a LLP where all the partners are body corporate, or where there is a combination that one or more partners are individuals and others are body corporate, then at least 2 individuals who are partners of such LLP, or if there is a body corporate, then nominee has to be appointed and he can become a designated partner, or nominees of such body corporate shall act as designated partner. So if there are 2 partners, A, B and XYZ Limited, XYZ Limited's nominee can become one of the designated partner, and compulsorily A has to be there as a designated partner because this requirement has also to be fulfilled. One person at least has to be a resident in India. So all these requirements have to be fulfilled. If all of them are body corporate, then they will appoint their nominees and they will become the designated partners, right? What is the what is different between partners and designated partners? Their responsibilities are different. That we will look at in the next topic. Coming to characteristics of LLP. Quickly, very easy question. They can directly give you any of the 3 or 4 characteristics and they will mention to write a short note on it. Okay. But I am thinking that I will prepare another YouTube shorts video for this, because it is a very most likely it can be asked as a question and we can cover it up within 3 minutes. So I will prepare another YouTube shorts for this topic. Okay. Coming to advantages of LLP form of organization. Very easy. Quickly, partners enjoy limited liability, flexible capital structure is there, easy to dissolve, unlike a company form of organization. It is organized and operates on the basis of an agreement, not unlike partnership. Here the agreement is necessary. provides flexibility without imposing detailed legal procedural requirement. So flexibility is also there as in partnership form of organization, and it is without any detailed procedure which is there in case of company form of organization. So it is easy to form, right? ऐसा है इसलिए ऐसा है, ऐसा है इसलिए ऐसा है, ऐसा करके आप याद रख सकते हो. Coming to the procedure of incorporation of LLP, we will make it very easy. This theory will be easy for you. Firstly, what are the incorporation documents? So two or more persons who want to form a lawful business का LLP, जिनको business करना है lawful business with a view to earn profit, they shall subscribe their names to an incorporation document, and this incorporation document it shall be filed with the registrar. So in company's case an LLP, the registrar is same. आपको फीस देना पड़ेगा. With which registrar? The state in which the registered office of the LLP is to be situated. Along with that, along with the incorporation document, a statement has also to be given. It is, the forms are prescribed. What is that statement? The statement is made by either an advocate or a CS or a CA or a cost accountant who is engaged in the formation of the LLP. The professional who is going to guide you for the formation of LLP, उनका यहाँ पे सब दिया है कि एडवोकेट हो सकता है, सीएस हो सकता है, सीएमए हो सकता है या सीए हो सकता है. And along with that, along with these people, this person, one of the anyone who subscribed his name to the incorporation document, that is the partner, he also have to give this statement. What statement? All the requirements of this act and the rules have been complied with in respect of incorporation of the company and incidental matters. So two people, one of the subscribers, that is the partner, and and this professional person, both have to give this declaration that they have incorporated it after following all the procedure given under the act, right? And this incorporation document, what shall this incorporation document contain? It will be in the form as may be prescribed by the rules. It shall have name of the LLP, proposed business of the LLP, address of the registered office of the LLP, नाम गाम पत्ता, right? Name, काम क्या करेगी, office का होगा. State the name and address of each of the person who are to be a partners of the LLP, designated partners of the LLP, and such other information as may be prescribed. Very easy. Name of the LLP, proposed business, address and registered office of the LLP, partners or designated partners का name and address. If जो हमने above statement discuss किया, if person makes a statement as discussed above, if he knows to be something false in it, that the statement is false, or he does not believe it to be true, if it is false, or if he knows that something is wrong, he shall be punishable with imprisonment for a term. And even if he gives, after knowing that something is false, something is not true, he gives the statement, then he shall be punishable for imprisonment for a term up to 2 years, along with it a fine which shall range from 10,000 to 5 lakh rupees. Once the registrar receives these documents, incorporation documents, he shall retain those documents, and within 14 days, he will register the incorporation document and give a certificate that the LLP is incorporated by the name specified in that incorporation certificate. This certificate issued, it will be signed by the registrar and it will be authenticated by his official seal. The certificate shall be conclusive evidence that LLP is incorporated by the name specified therein. So section 11 has the documents, the list of documents, 2-3 documents and the contents of the document. Section 12 says that such and such registrar will register the incorporation document within 14 days and he will issue a certificate of incorporation, that is given under section 12. Coming to section 13, it is about registered office of the LLP and any change in the registered office of the LLP. Registered office, why is it necessary to have? Because all the communications and notices, they will be addressed at the registered office. Manner of sending, how will the documents be sent? It can be by post, by registered post or by any other manner. If there is any change in the registered office, if there is a change in a registered office and you will in that case you will have to file a notice of such change with the registrar. So कुछ भी हुआ तो registrar को तो बताना ही पड़ेगा change होता है तो, and subject to such conditions as may be prescribed, and only the change will be effective after the filing of such changes done with the registrar. If there is default in this case, then again you have a fine. If you can remember it, well and good, otherwise don't waste your time in remembering the fine. Effect of registration. On registration, LLP shall by its name be capable of suing and being sued, holding property, disposing property, movable, immovable, tangible, intangible property in your own name, all the features like a company, having a common seal if you decide to have one, or it can do and suffer such other acts and things as a body corporate may lawfully do and suffer. Section 15, Section 16 and Section 17. Section 17 नहीं दिया है क्या इन्होंने, सारांश में नहीं दिया है. Okay, but Section 15, 16, 17 I have already discussed in a reel, you can check out on the channel. Coming to differences, last topic, difference with another form of organization. So what is the difference between LLP and partnership form of organization? सबसे पहले तो act. I'll tell you, remember all these points somehow, at least 5 to 10 points, and then this will be very easy difference between, right? So it is on the basis of regulating act कौन सा है, body corporate है, body corporate नहीं है, separate legal entity है, separate legal entity नहीं है, क्रिएशन कैसा हुआ है, बाय लीगल प्रोसेस अंडर द एलएलपी एक्ट, बाय अग्रीमेंट बिटवीन द पार्टनर्स, रजिस्ट्रेशन मैंडेटरी है, रजिस्ट्रेशन वॉलंटरी है, परपेचुअल सक्सेशन है, परपेचुअल सक्सेशन नहीं है, नेम जो है उसके लिए कुछ उन्होंने गाइडलाइंस दिए हैं, यहाँ पे कोई गाइडलाइंस नहीं है, लाइबिलिटी ऑफ ईच पार्टनर इज लिमिटेड टू द एक्सटेंट ऑफ अग्रीड कॉन्ट्रीब्यूशन एक्सेप्ट इन केस ऑफ विलफुल फ्रॉड, यहाँ पे हमेशा पार्टनर्स का लाइबिलिटी अनलिमिटेड रहेगा, लाइक डिपेंडिंग ऑन द टाइप ऑफ पार्टनर ऑल्सो, बट स्टिल इट इज ऑलवेज मोस्टली अनलिमिटेड. म्यूचुअल एजेंसी, each partner can bind the LLP but they cannot bind other partners, each partner can bind the firm as well as the other partners, right? So यहाँ पे जो है ना ये हम लोग का फीचर्स में डिस्कस होगा ये वाला पॉइंट. डेजिग्नेटेड पार्टनर्स एटलीस्ट 2 and 1 shall be resident in India, no provision for such case. डेजिग्नेटेड पार्टनर्स का मतलब क्या होता है, वो क्या करते हैं, फीचर्स में कवर होगा. कॉमन सील, इट में हैव इट्स कॉमन सील as its official signature and there is no such concept of common seal. लीगल कंप्लायंसेस का रिस्पॉन्सिबिलिटी होता है डेजिग्नेटेड पार्टनर्स पे और पेनल्टीज भी उनके ऊपर लगेगी, लेकिन यहाँ पे सारे पार्टनर्स रिस्पॉन्सिबल रहेंगे. यहाँ पे इन लोग को एनुअली कुछ स्टेटमेंट्स फाइल करने पड़ते हैं, लाइक एनुअल स्टेटमेंट ऑफ अकाउंट्स, स्टेटमेंट ऑफ सॉल्वेंसी, एनुअल रिटर्न विद द registration of LLP. Every year you have to file these documents, but this firm is not required to do any annual filing of the documents with the registrar of firms. Minor cannot be admitted to the benefits of LLP, but minor can be admitted to benefits of LLP with the prior consent of all the existing partners in case of a partnership firm. Coming to the difference between LLP versus limited liability company. Limited liability company मतलब क्या, company form of organization. So regulating act पता है आपको, members और partners कितना, यहाँ पे किसको पार्टनर बोलेंगे, द पर्सन हु कंट्रीब्यूट टू द एलएलपी, यहाँ पे जो शेयर्स में इन्वेस्ट करेगा उसको. इंटरनल गवर्नेंस स्ट्रक्चर जो है यहाँ पे अग्रीमेंट के हिसाब से डिवाइड होगा, तभी हमने बात किया था दैट देयर इज अ फ्लेक्सिबिलिटी इन द इंटरनल स्ट्रक्चर एंड हियर द इंटरनल स्ट्रक्चर इज रेगुलेटेड बाय द कंपनीज एक्ट 2013. नेम के लिए गाइडलाइन दिया है, यहाँ पे भी नेम के लिए क्या गाइडलाइन दिया है, दैट यू हैव टू राइट मिनिमम नंबर ऑफ मेंबर्स और पार्टनर्स, यू कैन मेंशन, वेरी इजी पॉइंट. हाउ इज द लायबिलिटी, वेरी इजी. Management responsibilities by the partners including the designated partners. The compliance is responsibilities on designated partners, but management responsibility is on all the partners, and the affairs of the company are managed by board of directors. Minimum number of directors or designated partners minimum 2 और यहाँ पे 2 and 3 जो उन्होंने दिया है. That's all, we are done with the LLP Act. I hope you found this video useful. If you found it a quick revision series, you can definitely share it with your friends. Do like, comment and share the video. See you in the next video.